Hello, Miss Marni.
Good morning. How are you? Well, I guess
Morning.
it's evening your time. It's morning my time.
Yeah, good morning to Canada. Thank you for being with us. I will officially start the webinar in a while now. Can I please know who is recording the session? Is it Salal or Ali?
Is Salal there and Sania, Fatma, so that they could also introduce themselves to Marni?
Yes, I shared the link with them, and they probably have 8 o'clock in mind. Sania is here.
Sania, would you like to introduce yourself to Marni?
Yes, hello, Ms. Marni. My name is Sania Fatma. I'm good. How are you?
Good.
Hope you're having a great day.
Yes.
My name is Sania Fatma. I'm a second-year law student. I'm working here with Adal Aur Sehat Legislation and Legal Policy Clinic, and I'm extremely excited for you to be with us today. I'm really looking forward to the lecture. Thank you so much.
You're welcome.
Awesome. So I think Salal is not here as yet. So we have in the lecture series department, Marni, we have Rahat, who's heading the department. Then we have Sania, and we also have Salal, who is about to join us, perhaps, who are helping Rahat with conducting these amazing webinars with all of you. So excellent in that sense. So I think before Salal joins, we can, if Marni, you could reintroduce us, so we know the fabulous work that you're doing with the clinic, of course. And I think the county clinic is doing a lot of things in a lot of disciplines. And one of those things and one of the discipline is the sexual harassment in the workplace. So would you please tell us about that, tell more about that to us?
Yes, so I am a part-time contract lawyer with the clinic. I'm not a full-time staff. I actually run a full-time practice as well. And my role at the clinic is with regards specifically to the sexual harassment in the workplace program. So I work out of the Renfrew County Legal Clinic, which is a clinic in Ontario, in Canada, in the province of Ontario. And I specifically deal with the sexual harassment in the workplace program. That program is funded by the federal government of Canada in trying to respond to issues of sexual harassment in the workplace that have become quite prevalent and more known in Canada as of recently. So my role is twofold. I am there to give summary advice to people who have experienced sexual harassment in the workplace, or to employers who are looking at how to deal with sexual harassment in the workplace. The clinic, as you know, is usually geared towards servicing low-income individuals who may not otherwise have access to legal assistance for various issues. That does not hold true for the sexual harassment in the workplace project, because it is funded nationally by the federal government as opposed to the regular clinic funding from the province. I don't have to do that screening. I can represent anybody. Funding income is not a barrier, regardless of how much they make. If somebody comes, then I can deal with them. I do not further the process in terms of making complaints or going to court or that sort of thing. I simply do the initial summary advice as to what their rights and their responsibilities are, what their avenues are, and what different things they could do to deal with it, and then make referrals or point them in the right direction. So that's the first part of what the project is doing the summary advice and actually dealing with clientele who come to the clinic with sexual harassment. As equally important, if not more so, I think, we're also doing public legal education, where we go out and do seminars and talks and lectures about sexual harassment in the workplace to educate people, because that's one of the things that we're finding. And I know we'll talk about that later on, but one of the things that we're finding is that a lot of the issue comes from people not understanding, people not knowing that they have avenues where they can go. So a big portion of what we're doing at the various clinics throughout the province that are working on the project is public legal education.
Fantastic. So I was, yes, browsing through the website as well, and it did mention public legal education. And absolutely, this is what Adal Aur Sehat is trying to instill in the Pakistani society also. And also we're trying as much as we can to spread legal awareness and spread the whatever rights people have and whatever laws there are to protect women and children and of course the people at large. So I think Salal is here after he introduces himself, and Marni, without any further ado, we'll just start. So I will be in the background and Rahat will be conducting the session. But lovely meeting you, Marni,
Nice
and
meeting you too.
fantastic. Good luck.
Hello, Ms. Marni. My name is Salal Malik. I am the associate of the collaboration and lecture series at the Legislation Policy Clinic of Adal Aur Sehat. I have been involved in making the content for the questionnaire that we presented to you today, and I hope we have a conductive and a very enlightening session on the matter that is before us. Very nice to meet you. Thank you.
Nice to meet you too.
All right, so I will now formally start the webinar. Assalamu alaikum, everyone. This is Rahat Sabah, Head of Lecture Series and Collaborations, Legislation and Policy Clinic by Adal Aur Sehat. This is the second episode of our lecture series. The theme for today's episode is the role of employers in curbing workplace harassment. The distinguished speaker for our lecture today is Ms. Marni Munsterman. Ms. Marni is a criminal defense barrister and solicitor with specialization in mental health issues. She's currently working with the Renfrew County Legal Clinic and is associated with the Sexual Harassment in the Workplace project. It's truly an honor to have you here, ma'am. Thank you for being with us.
Thank you for inviting me.
All right, so I will now move to the questions regarding today's topic. My first question to you, Ms. Marni, is what is the significance of having an internal harassment mechanism? An internal harassment complaint mechanism, rather. What are the merits and demerits of it? And a related question is how to ensure independence from any management influence and create a safe environment for the victim to report the matter to the Internal Harassment Committee.
Well, I think one of the important things about having it internal is that often the person who is the subject or the victim of sexual harassment, they may not want necessarily a formal legal process and to go through all of that. Essentially, a lot of the time we're finding what they just want is that behavior in the workplace to stop, both directed at them and directed at other people. So by having an internal mechanism, it gives them the ability to voice that concern and have it addressed internally without it becoming a big, perhaps, spectacle or a bunch of people knowing. We also know that going through legislated complaint processes, whether they be with tribunals, the courts, that sort of thing, often takes a long period of time. And with that, you're looking for other resources or other solutions, right? Not just to have it stop. So if there's an internal mechanism, it gives a person an opportunity to raise it right away and to hopefully have it dealt with by the employer or the manager right away to stop the behavior, to call out the perpetrator, to put things in place to stop that behavior, both towards them and anybody else in the workplace. So that certainly is a big benefit, is because it can be quick and it can assist in terms of hopefully curbing that behavior in the workplace fairly quickly. The demerit or downside of that, I think what you've touched on is that often people don't feel making that complaint within their workplace, if they don't know that there is a place to go that is, just give me a second, and that they feel that they're comfortable, that they're going to be listened to. Often they feel that perhaps the manager may not want to listen or to deal with it, because the issue often is that employers don't want to recognize that there is that issue within their organization as well, right? So that can be an issue. It can also be an issue employee who is a colleague, but if it is somebody who is a manager or the boss or that sort of thing, then that can also be difficult, because then who do they go to, right? So those can be issues. And also the issue of, if they complain within the workplace, they're not going to be believed, or that perhaps it's going to impact negatively on their employment, and the risk of losing employment or being demoted, not getting promotions, whatever the impact may be, because they're seen as a troublemaker. So when it's internal, that can be part of the concern and the issue as well.
Right. Thank you for such a comprehensive answer, Ms. Marni. And I think that's precisely why it's important to have a twofold mechanism, having an internal harassment complaint mechanism, and also having an internal tribunal or quasi-judicial tribunal to deal with workplace harassment, so that if an employee is not feeling comfortable or confident with the internal complaint mechanism, they can go to the tribunal created by the state.
That's great. And here in Ontario, that we have that mechanism set up. It is legislated, so it is our law that employers have to have a harassment policy in place and mechanisms to deal with workplace harassment, which includes sexual harassment. But there is also in place the mechanism that if an employee does not feel that that has been dealt with properly and investigated properly and dealt with to their satisfaction, they can then go outside of the organization that they work for and make a complaint to the ministry to have someone come and investigate that complaint and whether or not it was handled properly. And then we also have, as I said, the longer mechanisms if people are looking for other recourse, such as, financial recompensation if they've lost their job or if there's been difficulties, they can go through a formal complaint or a formal legal process as well. But certainly when we're looking just at complaining, making that complaint within the organization, we have mechanisms in place that if they feel that that is not dealt with to their satisfaction and is perhaps just swept under the rug, that they can make a complaint to the ministry to have it investigated.
Right, that makes perfect sense. Ms. Marni, my next question to you is about the role of employers. In your opinion, what role can employers play to create a culture of mutual respect at the workplace and to maintain a harassment-free workplace environment?
I think the role of the employer is paramount, right? They're the ones that set the tone for the employment. Here again, in Ontario, it is legislated that they must have that policy, and that policy must be available and posted, whether it be physically in a break room or on their website, so that all employees and managers have ready access to it, to know what the policies are and what the repercussions are if there is sexual harassment or harassment in the work. It's important to make sure that employers take it seriously, that they're making sure that their employment space is safe, that all employees are very clear on what is acceptable and not in the employment sphere, and that they are that everybody knows what is acceptable and what is not, and what happens when there's something that's not acceptable. I think that employers need in their role to be very open and transparent about that, and make it very clear. They also need to deal with any allegations or anything that they see quickly and swiftly and make sure that that behavior is not continuing, and to take investigations seriously when a complaint is made through the proper process. In addition to that, I think it's very important, and I think this gets back at what I was talking about earlier, that this is something that doesn't seem to be acknowledged or really understood in mainstream society as to how prevalent it is, and how much of a problem it can be, and the impact, how it goes beyond just the workplace. So how serious a problem it is and how it needs to be addressed. And I think that in addition to making sure that their policies are clear, both on what is not acceptable and how it will be dealt with, I think employers in their role have an obligation to make sure that there is proper training and education around workplace sexual harassment so that the employees know exactly what is not permissible and what the different forms, albeit sometimes very nuanced, can be, and how the employer is going to respond to that. So I think it's not only being upfront and very transparent, but they have an active role in making sure all of their employees and staff are educated as to what their rights are, as well as what their responsibilities are as an employee in the workplace, and how any harassment is going to be dealt with if it occurs.
Right. So my next question was related to something that you've already hinted upon. It is a fact that policy is something that's documentary. It will be on the website or it will be pasted somewhere in the office premises. But having actual sensitization regarding human dignity, regarding the gravity of workplace harassment is another thing. So you have already touched upon the importance of trainings in this regard. There should be on-work trainings for both employers and employees to sensitize them regarding workplace harassment, regarding human dignity. My question to you would be that should there be a legal requirement for such trainings for both employers and employees, considering how important it is?
I think absolutely in this day and age, so that we can deal with this issue, there should be. Because when we're looking at it, it's something that continues. We see more and more cases in the media, particularly, and I'm sure you get them over there too, a lot of the media with issues in the United States that have come forward that have really spearheaded a lot of this movement, and we see that it continues. But I think that we're not going to change things just by putting in policy and legislation and dealing with the issues as they arise. We really need to try and deal with it at the root cause. And that is through legal education and through understanding, so that people start to understand what and why the behavior is inappropriate, why and how it's not going to be accepted in the workplace, and that there are going to be swift and serious consequences for it in the workplace. And all of that starts, I think, with from the ground up, with education and seminars and information being provided to employees and to management as to what the situation is, what is unacceptable, and how it's going to be dealt with. And that may start to curb the incidence of what we see in the workplace. And in particular, and one of the things that I myself, when I'm doing public legal education, focus on when I'm doing it, when I'm going out and doing my public legal education and talks, what employers need to keep in mind is that they have an obligation to keep and to provide a safe, harassment-free workplace for their employees. But that goes beyond just the, and this is where we get into some of the, the human rights issues and that sort of thing. It goes beyond just protecting employees from other employees and managers. People working there is equally obligated to protect the employee from the customers and the clientele that they deal with. And there's research here in Canada that shows that a lot of the harassment particularly the sexual harassment that employees are experiencing in the workplace, doesn't necessarily come from other employees or management or higher ups in the organization. It comes from the clientele, from the customers that they are serving. And one of the problems that there has been long-standing is that adage that the customer is always right, right? So the employee feels they can't make a complaint, that it's not going to be dealt with, or employers don't want to deal with the issue because they're afraid of losing that clientele. And that's where it has to be made very clear for employers as well, that they have an obligation to protect their employees, not only from other individuals in the workplace that they work with, colleagues and managers, but also from the clients and the customers that they service. And that obligation also is not just for permanent full-time employees, but anybody in that employment sphere. So if they are students, if they are interns, if they are volunteers, if they are part-time, if they are contract, all of those individuals in that employment environment are equally protected, regardless of the type of their employment or volunteer status with the organization.
That's such an important insight that you just mentioned, Ms. Marni. Makes us realize that there is a need to increase the scope of who qualifies as employee, like those who are working on contract basis, who are interns, students as well, and also protecting them not from other employees or employers, but also clients and customers, because I am personally aware of instances where a worker has been made uncomfortable by a client. So it's really important what you just mentioned. A related question, Ms. Marni, do you think that the employer should be held liable for instances of workplace harassment at their workplace if there's gross negligence in creating safe workplace environment? And if so, what would constitute gross negligence in that case?
I think it's hard to define what gross negligence would be, but I think certainly you can see scenarios where the employer should be held responsible. You know, if it's a scenario where the complaint is made and they investigate it and they try and deal with it and they deal with the person who's responsible for the behavior, then they're doing their job. But if they're not upholding their responsibility to ensure that it's a safe workplace, if they're not dealing with instances of sexual harassment, they're sweeping it under the rug, they're not taking complaints seriously. As just, you know, an example, when I mentioned before, if they're not listening to employees who are complaining about a particular customer or client because they are valuing that customer client relationship better than their employee, then yes, in all of those scenarios that I think that the employer has to be held accountable because they're not upholding their legal obligation to provide the safe work environment. And here in Ontario, that's when people may go to the Human Rights Commission, to the Ministry of Labor, or file a court action against typically the employer, not just the other individual who was responsible for the sexual harassment, but making the employer accountable. And sometimes it's through legal means, sometimes it's through financial means, sometimes it's just in terms of getting some oversight and some supervision from, say, the ministry to make sure that they're dealing with things appropriately. But absolutely, if an employer is not fulfilling their obligation to make the employment environment a safe and place free of sexual harassment, then yes, they should be held accountable.
Right. I think the mechanism that you have in Canada, it's quite a sensible approach to take. Ms. Marni, my next question relates to the work that you are currently doing. So when the cases of workplace harassment are brought to your clinic, is there an evidential threshold for your clinic on the basis of which you decide whether the matter deserves legal opinion or not?
No, when somebody comes to me with a complaint of sexual harassment, then my role is to give them summary advice and direct them, you know, in terms of depending on what it is they're looking for. Are they looking just to have it stop? Do they want to file a formal complaint? My role is not to make any judgment as to whether or not it's an appropriate or there's any evidentiary basis. My role is to give them that advice as to what their rights are, what their responsibilities are, how they should deal with it, and what avenues they have to deal with it, and what kind of information they should be keeping so that whoever is assisting them in dealing with it, if it is a formal complaint or just through the employer, they have the information compiled that they need to be able to bring that complaint forward.
Fair enough. Ms. Marni, I think you did shed light upon it in the beginning of the session, but I'd like for you to elaborate on it. Why did your clinic chose to deal specifically with sexual workplace harassment?
So, as I said, this is a federal program that comes from the Canadian federal government, the Department of Justice, in recognition from a lot of media coverage and things coming out that sexual harassment in the workplace was a huge issue, that it wasn't well understood, and that it wasn't being dealt with properly, and a lot of it was kind of falling by the wayside. So there was funding put forward by the federal government to be for clinics such as mine to be able to put together a program to address it in that twofold issue that we talked about. So to deal with both public legal education, seeing that that is a huge part of it, and what is going to start to fix the problem, if you will, but also to give access to people to get that information and summary advice, because before they complain to their employer, they may want to have a sounding board. They may come to me for that summary advice to say, you know, for me to actually tell them, you know, do I think it's sexual harassment or not? What are their avenues, what they can do, so that they know when they go to complain to the employer that they have some information before they do that, right? So that was the program, that the funding that was put out for clinics to do that program. And my clinic was very interested in doing that. And that's how I was brought on specifically to do just this program. So for us, it's a 5-year program aimed at that public legal education and summary advice to try and provide more advice, because we were finding that and the research showed that not a lot of people were aware or acknowledging sexual harassment in the workplace, and certainly not many people who had experienced or observed it had made any complaints or had brought the matter forward so that somebody knew that it was happening so it could be addressed.
Right. It is indeed an issue that demands particular attention. So, Ms. Marni, the two primary functions of your clinic are providing public education and providing legal services. Perhaps since you have effective policies on workplace harassment, you have not advanced your role into policy amendments. However, if the applicable law was ineffective and not all-encompassing, what steps would your clinic take to bring about effective legislative change?
I'm not sure, and that's difficult in terms of what the roles of the different clinics are, but given the mechanism of the program, we would probably get together and make some recommendations as to what we were seeing in our individual practices and what some of the barriers and the difficulties were, and try and make those recommendations back to the policymakers as to what some of the issues were. That would likely involve us trying to get more than just some of the clinic individuals involved. But I think if that was part of the issue, that's probably where we would start.
Right. It is a valuable strategy that you just mentioned. Ms. Marni, based on your experience, what is more effective? you don't have to set a hierarchy. You may say that it's both functions are equally important, but based on your experience, what is a more effective service provided by your clinic to in terms of stopping harassment? Is it through public education initiatives, making people aware of what the parameters of sexual harassment are, or is it the access to legal advice that the clinic provides in cases of workplace harassment?
I think they're equally important, but what we're finding, and there are many clinics across Ontario that are doing this together. So we meet on a monthly basis to discuss the issues and to try and put together the program in a cohesive fashion across the province. And what we're finding is, despite we've been doing this now since late 2019, we're not getting a lot of people coming to the clinic for legal advice. And I think that gets back to the public education piece, that people aren't aware that it is such a problem, aren't aware that they have rights and they can have the issues addressed so that they're not subjected to it at work, or they don't know where to go to start that process and get that information. So whereas I think the summary legal advice and the legal assistance and legal services is very important to help curb the issue, if not as important, perhaps more, is the public legal education piece. Because in that public legal education piece, not only are we going out and providing materials and doing webinars and doing seminars and that kind of stuff, and talks about what sexual harassment in the workplace is, how it's defined, what it looks like, but we're also trying to give people the information as to what avenues they have to address it as well, and what their employer's responsibilities are. When we go out and talk to employers, we tell them what their responsibilities are, how they can create a safe environment, and what they need to do in supporting their employees. And it's sometimes, so I think we're starting to get a little more of the legal services and the advice piece, but I think that is only going to start coming and becoming more prevalent as there's more public legal education about what the issue is and how to address it.
Right. What you just mentioned, the lack of legal awareness is something that we can completely relate to here in Pakistan. But here it's a twofold issue, because although there have been some amendments at the federal level, at the provincial level, the harassment law is really ineffective. There are a lot of loopholes and shortcomings. So that's why the clinic is working to introduce amendments and make laws more effective as a first step. And then I think our clinic should engage in public education regarding awareness about the laws and sensitization among people regarding human dignity and the gravity of workplace harassment. Ms. Marni, my next question to you pertains to a human rights perspective on workplace harassment. Matters of sexual harassment in particular also overlap significantly with human rights issues. In your opinion, what are the parameters of sexual harassment at the workplace, and are they distinguished from matters of human rights?
Not necessarily, and just getting back in terms of, and I think it all kind of falls from what we were just talking about into this aspect. Part of when the federal government and Department of Justice decided to embark on this program to try and address this issue, there were some studies and some research done. And some of the statistics that I use in my presentations, just to give people a good example of what the problem here in Canada is that, and you know, the research was done primarily targeted at women in the employment sphere. But we know, like you say, from a human rights point of view, and I'll get into that in a minute, it goes far beyond that. But it gave them a starting point. And out of those, there were some surveys done. And in one particular survey, out of all of the women surveyed, 52% of those women said that at some time during their career, they had been sexually harassed at work. So over half of the women said during their period of their career, they had at some time experienced sexual harassment in the workplace. Out of those, all of those surveyed, 28% had said they had been touched sexually in the workplace. So we're looking at over half of the women surveyed having been harassed sexually in the workplace. Almost a third of them having been actually sexually assaulted in the workplace. So those are some pretty high numbers that show how difficult that is. And that was just women who were surveyed, right? It didn't include the men in the workplace, and we know victimized as well. Out of that, when asked how many people had actually reported it, had brought it to somebody's attention, only 4% of those people who had been sexually harassed at the workplace, only 4% of the women had actually reported it. And then they did go to ask men. So they didn't give us a number on how many men had been sexually harassed, but they did canvass how many men would have reported it. And it was less than 1% of men who had been sexually harassed in the workplace had reported it in some fashion to deal with it. So we see that it is a very high incidence of sexual harassment and even sexual assault in the workplace, but that the reporting is very, very low. And without reporting, it's not going to change, right? And I think that brings us to what you're asking in terms of the human rights issues, because it is a human right issue that you are entitled to be in a workplace that is safe and free of any type of harassment or assault, including sexual harassment. And we also, and one of the things that we focus on is that sexual harassment isn't bound by gender, it isn't bound by sexual orientation, it isn't bound by any of those things. And so that it may happen that the prevalence is more towards women as the victim. That doesn't discount or take away from when a male is a victim or make it any less serious. And that sexual harassment isn't also, when we're looking at human rights issues and gender equality and that sort of thing, sexual harassment is not just defined as perpetrated a male against a female. And it's not just sexual touching or sexual innuendo. Anything that deals with gender orientation, sexual orientation, any sexual connoisseur, any sexual content, that is all sexual harassment as we've defined it here. So we're trying to keep a broad definition that encompasses all of those different human rights issues, so that if people are being harassed because of their sexual orientation or their gender identity, that falls within sexual harassment as well.
Right. Ms. Marni, just a follow-up question from what you just said. In a lot of international laws on workplace harassment that I studied, when they're defining workplace harassment, it's not just gender that's a protected category. It's also sexual orientation, it's also ethnicity, it's also religion. That's not the case in Pakistan. And could you please shed some light on what are the protected categories in the workplace harassment law in Canada? And have you experienced, in your experience, has anyone from third gender, from transgender community ever come to you with the sexual harassment complaint? Does the law cover the third gender under its protections?
Yes. So in Canada and in Ontario, particularly, because that's where our employment law is provincial, but overseen by the federal. So in terms of harassment itself, all of those things are covered in harassment, whether it be religion, ethnicity, gender identity, sexual orientation, all of that is included in harassment. And that's where I said an employer has to have a harassment policy. That includes the subset of sexual harassment, because we know that that is very specific in terms of the type of harassment it is, right? So in our definition, and the legislation that we have here in Ontario specifically sets out that things such as gender identity, sexual orientation, marital status, all of those things are protected under the sexual harassment umbrella. And harassing somebody about any of those issues is defined as sexual harassment. And that is regardless of the person's race, religion, or any of those identifiers. None of that qualifies what sexual harassment is. Sexual harassment is sexual harassment regardless of any political affiliations, any gender issues, any religious or racial connections. Everybody is equally protected regardless of what those ideas and beliefs are.
That's great, and I hope we can have that in Pakistan too, because in Pakistan the only protected category under the workplace harassment law is gender. My final question to you, Ms. Marni: power dynamics at the workplace often play in the favor of men. What would you say about the intersectionality of power and gender at the workplace? What strategy would you suggest that employers can use to rectify the imbalances, both in terms of number and hierarchy?
Well, I think, again, it has to be that an employer has to have a clear policy in terms of what appropriate interactions between employees are, and to make it very clear that there are not those power imbalances or differences for gender, right? And one of the things that we see and that has become very obvious and prevalent in Canada is that power imbalance, and even if it's not a gender power imbalance, but that power imbalance often is what leads to or where the sexual harassment occurs when one person is in a position of authority or power over somebody else in the employment. It makes that person vulnerable. Sometimes it makes them that they are secluded or you know, they're not having access to other individuals, that sort of thing. So that really needs to be addressed, and that needs to as well be something that employers are very attuned to and looking for, that people in positions of authority, their management, that sort of thing, is not abusing that authority. Because when that happens, that's where often we see that the individual who is the victim of the sexual harassment does not feel comfortable bringing the complaint forward because it's again them. Perhaps they feel that they're going to lose their employment, or they're going to be demoted, or something's going to happen to them employment wise. So that's where employers have an obligation to make it very clear that it is unacceptable, regardless of what the situation and the rules are, regardless of whether there is that power imbalance, that it's still unacceptable, that just because somebody has a position of authority over you, that it doesn't mean that they have that ability to behave in that fashion at the workplace. I think, and we're seeing in Canada as well, that one of the things trying to deal with that is looking at hiring policies and trying to make it so that it's a more balanced workplace, so that maybe there isn't that male-female gender inequality. But as I said, we have to be careful not, I think, to just focus on that, because we don't want to delegitimize or take away from the fact that it doesn't, though it often happens, and that's where often the statistics tell us that it's when there's that power imbalance, it's the male in power and the female who's the vulnerable and is often the victim of sexual harassment. We don't want to make it seem or appear that that is the only way it is, because then that less than 1% of males, that number is never going to increase. It's already hard, I think, for males in society to admit that they've been victimized in this way, let alone to come forward. So while we have to keep in mind where the majority of that is perhaps male against female, we have to, in our public legal education, make sure that everybody is aware that that's not the only scenario that it happens in, and that there are women in power who can do the same thing, that it's, again, it's We don't define it by gender, we define it by the behavior.
Fair enough. Thank you for such an insightful session, Ms. Marni. Thank you so much for your time. It was wonderful to have you here. And it was such a great learning experience. We're truly indebted to you for your insightful comments.
Thank you very much.